Jen, it's nice to see you. This is Barbara Beckert. Thank you so much for being part of this training today.
You're
Great.
welcome.
Give me a second and we'll go live on Facebook and get started. Hi, this is Sally from the Wisconsin Board for People with Developmental Disabilities. It's another Living Well Wednesday, and we have a great group with us here today to present on voting and guardianship. We are excited to have Wendy Heyn, and Barbara Beckert is also on from the Wisconsin Disability Vote Coalition. We have our self-advocate Jen, who's going to talk about her story of restoring her right to vote. Mitch Hagopian is with us from Disability Rights Wisconsin to talk about the legal aspects of restoring your right to vote. And Patty's here as a parent and a guardian who went through the process of trying to retain her daughter's right to vote, and we'll hear from her. And then Caitlin will wrap it all up at the end with a little bit of information on supported decision making. So we have a lot to get to. So I'm gonna turn it over to Wendy right away. She's gonna give us an overview kind of voting and guardianship. Thanks a lot. Take it away, Wendy.
Hi, my name is Wendy Heyn, and I do voter outreach and advocacy for Disability Rights Wisconsin, and we're part of the Wisconsin Disability Vote Coalition. We provide assistance to voters with disabilities and their allies with our voter hotline. So we have the number, it's actually in the group chat right now, 1-844-DISVOTE, that we can help you with any voting related needs that you have. We can help you figure out who to contact if you have questions that we can't answer. And so that's what we do. We help out. We also provide training and resources through the Disability Vote Coalition, and we coordinate that with the Board for People with Developmental Disabilities. And one thing that often comes up when we're out doing trainings, when we're in the community, is questions about voting rights and guardianship. It's an area that a lot of people just don't really understand. And in Wisconsin, people under guardianship actually retain their right to vote unless the court expressly removes it. So, and that's something that a lot of people actually aren't even aware of. When I do transition fairs, I often have people feeling surprised because they didn't know that was even a possibility for them and their loved ones. Sometimes people go through the guardianship process and they're under guardianship, or they are a guardian, and they actually don't know if the right to vote is something that they have, or that it's been taken away. So we get questions from people who maybe don't even know the status of their voting rights. So again, as I said, in Wisconsin, a person under guardianship retains the right to vote unless the court expressly removes it. A person who has a guardian and has lost the right to vote can petition the court to restore their right to vote. And again, I think Sally mentioned that, talked to us after a while, and Jen actually went through that. So, but in today's discussion, we're going to talk about how someone under guardianship can determine if they have the right to vote. We're going to talk about the process for a person who has a guardianship and has lost that right to vote, but wants to petition the court to restore their right. And we're going to talk about what resource materials we have available to you to help you out with figuring this out. Resource materials that you can share. They're all available at our website at disabilityvote.org. We're going to hear from Jennifer and Patty, and then we're going to hear from our attorney at DRW, Mitch Hagopian, who has created some of our materials explaining to you how to piece all these things together. This isn't, legal things are always complicated, and this is no exception. We have a fantastic brochure that's also available at our website And it's a guardianship brochure. And a lot of people, as I said to you, if they're under guardianship, they may not know the status of their voting rights. And so in our brochure, it actually explains to you where to look to find that out. And it explains to you how to get the document if maybe it got misplaced by the guardian or by you. So we have lots of materials available to you, and we are here at the 1-844 DIS vote number to guide you if you have questions. And so I'm gonna actually, I will turn it over to Jen, I believe, to or back to Sally, I'm not sure, to talk to you more about particular situations, and then and how to understand these things better.
Thanks, Wendy. That's great. Yeah, I'll just introduce Jen and let people know that in the chat we have linked all those resources.
I did already.
We have linked all those resources that Wendy was talking about, so you can get them right there. So Jen, thanks so much for joining us. If you just want to get started, I know you're gonna kind of tell us your story, and then I'll ask you a couple additional questions.
Okay. Hello everyone, as you know, my name is Jennifer Cratch. I am here to tell you about how I was able to get my right to vote. When I was 18 years old, I was assigned a corporate guardian and was told I was incompetent and was not able to vote. I joined my local People First chapter in Ozaukee County in 2014 and was elected to be the secretary. I still hold that position today. People First has helped me to become a stronger self-advocate. I attended the Self-Determination Conference in 2015, and the keynote speaker was a lawyer named Jonathan Martinez. He spoke about Jenny Hatch and how he helped her get her rights back. At that time, I decided I wanted to get my right to vote back too. When I got home, I contacted my guardian, and she told me she needed to hire a lawyer and would get back to me. After many phone calls and months of no progress, I was informed in June of 2016 that I had a court date for that August. That day when I arrived at the Ozaukee courthouse, I sat with my lawyer, and the court commissioner, Barry Boulogne, asked me if I wanted to have my right to vote. I stated yes, and after several more questions, I was now granted the right to vote. I voted for the first time in the presidential election in 2016 and have voted in every primary and election since. I encourage you, if you are under guardianship and want to vote, to contact your guardian and let them know you would like to vote and don't give up. It took me a total of 10 months and it was worth it. And I voted yesterday.
That's great. I have a picture of you getting your rights restored too. I'm going to share that on the screen so people can see. So that's when the judge said you were able to vote again, right? That was the day in court. The judge looks pretty happy about it too. I think he must have been excited to be able to do that for you.
Mm-hmm.
So just thinking about, so you did vote yesterday.
Yes,
did you
I
vote
did.
in person, or
Yes, in person.
Have you voted by mail yet, or?
No.
Okay. Yeah, you like going in person, right?
Mm-hmm.
Yeah, after that. So how did you get the information that you weren't able to vote? Where did you find that information?
I contacted my guardian, asked her about it because I first turned 18, the judge told me and my guardian and to our face that I was incompetent.
Right,
So,
okay,
like I said, after the conference, I kind of, my guardian asked her about it too, and she looked at the guardianship papers and everything, and it even said in the guardianship papers that I was incompetent of voting.
okay,
And
okay.
I told her, I said, could I petition the court to get my right to vote back? And she said, yes.
And did anyone talk to you about that before the guardianship? You know, like I always think like if
No.
somebody maybe had talked to you about that before it happened, you maybe
No.
would have known. Okay. And then
Nobody.
nobody talked to you about that. Yeah, I think that can be something that just happens and people don't usually know. And so how about you obviously had to register then to vote, right?
Mm-hmm.
And was that process pretty easy? Did you feel like that was a simple process for you?
Yeah, it was. It was pretty easy with having all the right stuff for it and everything.
So when you go vote, do you have someone come help you or have you done it yourself?
Mm-mm.
Okay. And
I do it myself. I don't need help.
okay. And you think it's a pretty easy process to go vote?
Mm-hmm.
And are you going to vote in the fall election too?
Yes.
That's great. That's great. Any other words of wisdom you might want to give to other self-advocates out there who want to restore their right to vote?
Just ask their guardian or their parents to see if they have their guardianship paper and see if what it says in their guardianship papers, if they can or cannot vote, and see what their guardian or parents say to them to see if they want to ask, if the people who don't have the right, if they ask their guardian or their parents if they want to fight want to get a petition to go to the court to get their right right to vote, they should talk to their guardian and their parents to see like I did. And that's how I got my process going, because I actually got with my guardian. That's how I found out that I didn't have my right to vote.
So there is a question
Fighting.
Wendy's saying, have you helped any other self-advocates get their rights
Two.
restored?
Two others through Project Vote.
Okay.
With my People First group,
Mm-hmm.
we had a grant, a Sparks grant from the Self-Determination Conference that gave it to us. So we did a Sparks grant called a Project Vote.
That's excellent. I know Wendy had talked about like it's pretty simple to get the document from the court, and it will only cost $2 or something to get the copy of the document where you could check to see if you are able to vote. So pretty simple to do, and I'm sure Mitch will talk about that a little bit more. All right, thanks a lot, Jen. I'm gonna now turn it over to our legal expert, Mitch. He's gonna give us the legal aspects and help people understand how they can get that right restored. Take it away, Mitch.
Hello, everybody. I'm Mitch Hagopian. I'm an attorney with Disability Rights Wisconsin, and we're the part I work for. I mean, Wendy works for it, and Sally used to. I work for the protection and advocacy part, so we're not technically in the disability, the vote part of it. So we work to protect people's rights, and one of those is the right to vote. So so this business of getting your right to vote back, as Jen and Wendy both said, the first thing you need to know is that you might never have lost your right to vote. In Wisconsin right now, the only way you can lose your right to vote is if a court takes it away from you in the guardianship proceeding. So what that means is that, you know, if you go to try to vote and an election official thinks you're not competent enough to vote for whatever reason, they can't tell you not to vote. All they can do is refer you to a court. Okay, so if you haven't lost the right to vote and you know, you haven't been told that you've lost the right to vote, and you go to vote and the court person says you can't vote, you need to tell them, well, you show me why I can't vote. You show me a court that said I can't vote, and then I'll listen to you. But so that's one thing you should know. Only a court can take it away from you. So the first thing you have to find out, though, is, before the election, you probably, if you can avoid the kind of the fight with the local voting people, that'd be good. So you want to find out, if you're under guardianship, you want to find out if, when that happened, if the court did take away your right to vote. And every time there's a guardianship, there's an order at the end of the proceeding. And in Wisconsin now, there's a specific little box on every single guardianship order that says whether or not your right to vote has been taken away. So what you're going to want to do if you're under guardianship and you don't know for sure whether your right to vote has been taken away, you want to first ask your guardian, hey, show me the order. Did I lose my right to vote? And they'll be able to tell you, and they should tell you. It's, your right to know what rights you have and what rights you don't have under the guardianship. So if they tell you that, in fact, when the guardianship started, the court did take your right to vote away, then you know, and you now think, I want to vote, and I think I know how to vote, and I think I know why I should be able to vote. Well, then you have to start a little procedure, because only the court, once the court took the vote away, only the court can give it back to you. So what you have to do then is file a piece of paper with the court in the county that where the guardianship is. And in that little paper, doesn't have to be a long paper, it just has to say that, you want your right to vote restored. And we have a little form we put together that anybody can use. You don't have to have a lawyer do this for you. If you're a person who wants their right to vote back, you can file this paper, which is in official language is called a petition. File this petition in the court where the guardianship happened. And what that petition does is basically starts a whole little court process. Not a big court process, a little court process that is only about whether or not you should be able to vote if you can't vote now. So you complete this document. It's, kind of a form. So really mostly what you have to do is just sign it. Then make sure it gets filed in your county. Usually the place you file stuff when you're trying to deal with a guardianship is in the office of the court that's called the Register and Probate. All guardianships are part of what they call the probate court branch. Just remember the word probate and ask for the Register and Probate. And once that happens, like I said, it triggers a whole process. And the process that happens then is, at that point, the judge or the court commissioner, whoever gets assigned to this petition, will tell you who you have to send the petition to. A bunch of people might be interested in whether or not you should vote. And the court is the one that decides which of those people gets notice about it. And usually it was going to be your guardian. It might be if you're in IRIS or family care, it might be your MCO or your IRIS consulting agency. Anybody that they think should know about this, who might have an opinion about this, they can tell you who that petition should be sent to. Sometimes the court will send it out for you. Sometimes they'll tell you, hey, you need to send it to these people. So whatever they tell you to do, you just do it. And if you got someone to help you, it's always good. Like I said, you don't have to have a lawyer help you with this, but it certainly doesn't hurt if you've got a lawyer. But anybody else can help you. They can't actually, sign the document for you. But if you've got a friend or, an advocate, they can help you kind of navigate this process. So one of the things we have on the petition is anytime you want to change anything about the guardianship, you can ask to have an attorney appointed for you by the court. And in the little petition that we have prepared for this, that is one of the things that we have in there. And you can, if you think you want an attorney, you can ask for one. And then the court is supposed to appoint you one. And if you can't afford one, they're supposed to give you one for free. So if you want an attorney, you can get one after it gets started. But like I said, to get it started, all you have to do is file the paper. After that, you might be able to get an attorney appointed by the court. So you've filed the petition, and now, there's the next thing that happens after that. You've sent it to whoever the judge told you to send it to. The next thing that happens is that the court's going to appoint somebody called a guardian ad litem. Sometimes they abbreviate that as GAL. And this guardian ad litem is actually not a guardian. This is a lawyer, another lawyer. And that lawyer is appointed not to represent you, but to represent your best interest. It's kind of a strange way to have a lawyer, but that's what the lawyer is there to do. And basically the lawyer is there, that guardian ad litem is there to advise the court as to whether or not they think you should get the right to vote back. So they're kind of a neutral person. They're looking at you, and they should talk to you and ask you about things, about voting. And then at the end of that conversation, when it gets to the time when the court's going to make the decision, then they say, well, I've talked to this person. I know this about this person, and I think they should get their right to vote back. Or I don't think they should get their right to vote back. And then they explain whatever their position is to the judge. So the guardian ad litem isn't your attorney, but they can help you a lot. If you can convince that guardian ad litem that you should get your right to vote back, you should probably get your right to vote back. And if they say that you shouldn't, well, that's an obstacle, but it's one that you can overcome. And I don't know, maybe at some point after I'm done, Jen can tell us if, there was a guardian ad litem appointed in her case or not. Sometimes the court might just not do it, but probably there was one. So you've got the guardian ad litem, you've probably talked to the guardian ad litem. The next thing that's going to happen is there's going to be an actual little court hearing. And, in normal times, which means not when we're under this COVID business, that would mean you would go to court, to the local courthouse in your county, or whatever county the guardianship is filed in. And there will be a little hearing. It's not a big trial, not like you see on TV. It's going to be, Jen can tell us a little, sound like it's kind of informal. And then you're going to have to explain to the judge why you think you should get your right to vote back. And Jen mentioned that, the judge asked her a few questions. And in Wisconsin, the standard to vote is not real high. I mean, you don't have to be a super genius in order to get the right to vote. We in the United States, we want everyone to vote unless they really, really, really don't understand the process. So the legal standard, if you were to look at the law, it basically says the only way you can lose your right to vote is if you are incapable of understanding the objective of the elective process. So what that means is, that's a fancy way of saying, do you know why we have elections? Well, you have to be able to answer that question to the judge's satisfaction. So you're going to have to explain to the judge why you think we have elections. And what's a pretty good reason to have elections? Well, we have elections to pick the people who make decisions for us. That's basically what an election is for. And if you can articulate that standard to the judge, that should be enough to convince him that, you are capable of understanding what an election is for. And so therefore you should be able to participate in that election, meaning you should be able to vote in that election. And there are different ways, that you might want to explain that to the judge. Say, well, make it concrete. The election's coming up in November this year, and we're gonna have to choose between Donald Trump and Joe Biden for president. So if you can tell the judge, well, elections to decide whether or not we're going to have Joe Biden or Donald Trump for president. That shows you understand what the elective process is all about. So it doesn't have to be a complicated, or deep understanding. A couple sentences should be enough to show the judge that you do understand what the process is about. And then, the guardian ad litem is going to say his piece or her piece as to whether or not they think you should vote. And And then after the judge gets all that information, it's going to make a decision. Now, in addition to you testifying and the guardian ad litem testifying, if you know other people who can help you and who know about your understanding of, what elections are about, bring them along and ask them to testify too. So I have a friend who had a client who wanted to get his right to vote back. And this is a young man who had spent, a lot of time in school working on, student council elections and things like that. And so he was able to bring one of his old teachers in and say, hey, I know that Joe knows what an election's about. I know that because he worked on a bunch of them when he was in high school. So there are other people in your life who might be able to say, yeah, Joe knows about elections because we talk about them all the time and he's up on current events and, whatever. Again, the main thing is, do you understand it and can you explain that understanding to the judge? But it doesn't hurt and it certainly helps to have other people kind of weigh in on your side. But this whole thing, it's in the court, so it's a little formal. I mean, you got to go in front of a judge and, you saw Jenn, that cool picture of her with the judge. Everybody's, it's a pretty proud moment if you get your right to vote back, because that's kind of the basis for what our whole country is about. We pick these people and everybody ought to have the chance to have a say in who it is who's going to make these decisions for us. So once you get the hearing, the judge will, I think in virtually every case, at the end of this thing, everybody's testified, you've explained to the judge, the guardian ad litem has, made his opinion, your witnesses have testified. Then the judge is he's going to issue a decision. And in almost all these cases, he's going to say right then and there, well, I've listened to the evidence and I agree that, you understand the purpose of an election. And so I'm going to grant your right to vote back to you. And then at that point, there's some paperwork that has to be done. The guardianship order, if it used to say that you didn't have the right to vote, they're going to have to, a new one will be created. If you have an attorney, your attorney will do it. Otherwise, maybe the guardian ad litem or even the court will prepare a new order that changes that box from don't have the right to vote to retains the right to vote. And then after that, the information then, you should always get a copy of that order, that guardianship order, and keep it with you. And then, at that point, you can register to vote and you can't be barred from voting in the next election. So that's a little bit of the overview. Like I said, it's a court process, but it's not a real tricky one, not a complicated one. And it's one that people should be able to navigate. Once they get it started, it kind of develops a little life of its own, which is a good thing because some of those hoops can be a little tricky. They're not hard, but it helps that we have the registers and probate and other people within the system who sort of make things happen that are supposed to happen in that process. So that's my little spiel for now. Happy to answer any questions. And what I would really like to hear, I don't know if Jenn's comfortable with this, but Jenn, if you could tell us what kind of questions did the judge ask you when you talked to him about, why you wanted your right to vote back? Go ahead.
You can go ahead, Jenn. Do you remember what questions he asked?
I don't remember the questions.
Okay.
Well, whatever he asked you must have answered them exactly correctly because you got your right to vote back. So.
Yeah.
Do you remember if you had a guardian ad litem, that person who was kind of that neutral person?
Yes, I had a lawyer from it was a guardian. It wasn't a lawyer. It was a guardian ad litem.
Okay.
Sent it to me.
And did that person report they thought you should be able to vote?
Yes.
Okay.
Yeah. See, they can be a big help. Even if you don't have your own lawyer, the
Right.
guardian ad litem can help you.
So there was a question, it seems it's probably from a guardian, and that she's had wards who have tried to petition, but then the county won't schedule a hearing. Is that, it says, just wondering if the county has to file a petition for the hearing. I've had wards who want to have a hearing, but the county would not petition the court for a hearing.
The county is not obligated to file a petition. Nope. That's why we have our own little petition.
Okay, so that form you're talking about.
Right.
So if the guardian is going to the county can say, no, we're not going to do that. But the person and the guardian have a right to file that little petition you talked about.
Right.
Okay.
Yep. And so, I mean, what happens, it sounds like what happened in those cases are that the county probably didn't tell that guardian that you can file it. All you have to do is file this one piece of paper and that'll trigger the whole process, whether we want it to happen or not. So, yeah, so that's how we developed this little petition. And we have two of them. One of them is if the person themselves, you know, like Jen, if she just wanted to file it on her own, then we have a petition that's in a form where she can sign it and file it. Then we have another one where somebody else who might be helping a person to get their right to vote back can file it also. So two different ways to start it. But once it gets started, that triggers a whole little process.
And then Barbara just noted that most of the proceedings right now, like in Milwaukee, are happening via Zoom. I wondered, how long does the process take? Like if somebody's listening today and they're thinking, I want to vote by November, you know, can the process go quickly or?
It can go quickly. I mean, because there isn't, in a petition like this, the guardian ad litem should be appointed and the guardian ad litem should do an interview, but there's no other like medical evaluations or anything like that. So there's no big reason why it should be delayed. Courts, you know, they're courts, they go slow. So once you file the petition, you know, contacting that register and probate to make sure that it's moving along, especially if there's an election coming up and you know, you want to vote in it, like between now and November, if you're going to start this process, you should do it pretty quickly now, because it does take probably a couple months at least to get through it, even if it's going kind of quick.
Okay. And those forms, are those on the Wisconsin Disability Vote Coalition page? Because we've shared a bunch of resources. Or is that on in DRW's stuff? Maybe
I'm going to defer to Barbara on that one. I don't exactly know where.
Yeah, maybe Barbara or Wendy could just answer, then we'll know.
Yeah, the forms are currently being reviewed by judges in probate court. So I think that our plan had been to wait until some of that feedback was received, and that we had indicated in the initial materials that anyone wishing to get the forms could contact us at the info@disabilityvote.org. I mean, we wouldn't say if someone wants to move forward now, but we didn't want to post them until we had them a little bit more finalized and get that input from the judges, and then we can have something that would be on the website moving forward.
Right. Yeah. So the official formal versions will be up, and those will be, they might be a little bit different. They're not going to be a lot different than what we've already got. And what we have right now, if you want it, we're happy to share it with you, and it will achieve your purpose, which is to get you back into court so you can talk to the judge about why you want your right to vote restored.
Okay, great. So that hotline we posted and also the website are where you can reach out for information for to the Disability Vote Coalition.
Yeah, email at info@disabilityvote.org. We're happy to share the materials and both the DRW brochure on voting competency and guardianship, as well as a nice overview of the process to give people a sense of what's involved. Those are posted right now on the Disability Vote Coalition website.
Yeah, and we put those links. We put those links in the chat. And then I did see one of our national partners from Living Well did post a link for a video that California made on the right to vote for people with IDD. So just something to look at in our chat there. So thanks a lot, Mitch. If Still, people, if you have any questions, just post them and we'll get to them. But I'm going to turn it over now to Patty. And Patty's going to talk a little bit about her journey with guardianship and voting. And I'm sure Patty's sitting here thinking, I'm going to petition the court tomorrow to get her daughter's rights restored. So take it away, Patty.
Okay, great. Thanks. Thank you. And I do wear a couple of hats. I'm also employed with the Adaptive Community Approach program and currently teaching advocacy. But my daughter is 27. When we went through the guardianship process, I was prepared to ask that her right to vote stay, that she still be able to, even though we were going to be named her guardians. And the thing that was somewhat alarming to me was that the person who was overseeing our proceedings was a little defiant with me about getting her, well, I don't want to say rights restored. It was just to be able to vote. She just really took issue with me on it. I was prepared at that time with some information about how people vote, and that I felt comfortable that because my daughter had learned in school how to make choices, that if given the right information, that she should be able to choose a candidate of her choice, that she has things she likes and things that she definitely dislikes. Well, at that point, both the person who was doing the psych eval and the judge became very upset with me and basically said that if I wanted to get the guardianship done that day, that we would table this, and that her rights would be taken away at that. And so I felt at that point that I really didn't really know what to do. And, you know, for any parents that might be listening, they know what that process is like. At that point, it's a long and lengthy transition from being a kid to an adult for a person with a disability. So I let it go. And then as I started teaching advocacy, and in this particular instance, at ACAP, we've been working on getting our membership to registered to vote. And during the process, we currently have 90 members. And during the process, we noted that about a third of our members were registered to vote and we're planning on it. But we had a third of members who some didn't know whether or not they were eligible. And in talking with family members, they weren't sure if they were eligible. And basically we were just asking about that. Do you know if your loved one is eligible or not to vote? But what ended up happening was it was bringing up lots of controversy about voter fraud, and that they didn't feel that their loved one would be able to make this decision correctly. And I started seeing that this was a bigger issue. For my daughter, she doesn't have language except augmentative communication. So there was that layer. And right away I thought, well, okay, you know, does anybody have PECS pictures of anything? We started looking at that. Then I started talking with people about, throughout the state about why isn't Wisconsin allowing people with disabilities, everybody to vote. And I got a chance to start looking into some of those laws a little bit more. And I have not gotten to the point where I've contacted Indiana and Illinois, because those states are nearby and they do allow everybody to vote, which I plan to do, because I guess I kind of see what I'm going to be up against is kind of threefold. One is that people need to be able to understand and be able to state this process, the election process. And so right away there, I'm like, well, how are you going to do that? If I'm inputting information, how am I going to be able to prove that this is something that somebody learned? Which then kind of stemmed into my whole other process of thinking as to why aren't we teaching this back in school? Because something should already be established. If they taught my daughter how to choose between two things that she liked, she should have learned how to choose between two candidates. So that was one thing. Talk about the how do we know that she knows what she's talking about? And so that brings me to the next subject of how am I going to prove this? And I'm going to need to get some good background information, some resources that that my daughter and a lot of other people who are not able to verbally communicate, that use augmentative communication, who have people that support them, that help them kind of process this kind of information, how they're going to be able to prove that, that they can make a choice and that they should have the right to vote. So yeah, I kind of opened up Pandora's box. My situation, when I look back on this, which it's been about 10 years since Olivia went through this process, I kind of kick myself every election that I was not assisted more to prepare for that hearing, because had I known that I needed her to prove that she understood the process, I would have maybe had that become part of her IEP, so that we would have known what to do at that point. So yeah, I know I only have 10 minutes and I do have lots and lots of stuff to say, but I don't know if anybody has any questions or comments.
I don't see any questions. I don't see any questions, but you know, Patty, that is a great idea as for youth who are in transition, that putting that in their transition plan. I mean, I think parents know, you know, voting may be part of the education, but really making sure that that is part of a good transition plan. I think that's a really great idea. And again, right. I think the important thing that you said too is that, you know, there are guardians or parents of adults that you've reached out to who weren't even necessarily aware that that right was taken away. And so I guess again, you know, as people are approaching guardianship for their loved ones or assigning a corporate guardian, you know, just making sure that people clearly understand that process, I think is so important. And
yeah, I'm sorry.
Go ahead.
I was just going to throw out too that one of the things that I noticed some of the families said was how, well, two things. One was the whole idea that they felt that this was voter fraud, that we were telling people how they should vote. And then the other one was, one parent said to me, well, would they really understand who to vote for? And so I informed them that, you know, as somebody who's teaching advocacy and voting, we have, and we're an agency, we have to show a bipartisan approach. And we're working really hard to find out what both sides, what all the sides are saying as it affects people with disabilities. And then what we do is we are breaking that down into ways that they can learn it. And so we're right now working on coming up with these visual symbols or visual ways that people might be able to understand these various policies. So, you know, I'm taking what we get from WI-BPDD or disability rights and information about or different questions, and trying to come up with ways that our membership can then articulate, whether it be augmentative or through pictures, to be able to ask these questions. And I did say to some of the parents that they're probably going to know more about our candidates than you probably will know. And because we're spending so much time on that, we're bringing in the candidates to talk with our members. And it's been quite an eye-opening experience. And one of the things that I'm trying to do as we're navigating through this is not to force this down families' throats. I'm not trying to say, you need to get out and vote and blah, blah, blah. I want them to want this. I want them to want to be part of the process. And to do that, I feel like as an agency, we need to come up with all of these tools on how we can help members. So I know I started kind of alluding to some of that with Barbara when I had contacted her about this, that I almost think we've missed something. You know, we formed people first, but we have this group of people that while they're wanting to advocate for themselves, they don't have the tools to come up with how to do that. And by the tools, I mean these symbols or photos or PEC symbols, or that there even be some, we use Go Talk now a lot at ACAP, and that there be a program that's out there that families could then input the candidates into this, and that people could begin this cause and effect learning style to being able to choose what it is they want. So just some ideas.
Very great ideas. Very great ideas. We really appreciate you sharing. And so I'm going to turn it over to Caitlin. She's going to talk a little bit about supported decision-making. This is an alternative to guardianship, and something you might, that when thinking about guardianship, this is, you know, might come up. So take it away, Caitlin.
Yeah, hi. So we're just going to talk a little bit about supported decision-making as an alternative to guardianship. This is something that you can do if you don't already have a guardian that takes the place of guardianship in a lot of circumstances, in that it creates formalized relationships with supporters who can help you make decisions about, you know, things in your life. And this process wouldn't involve you needing to show that you were able to vote. You would be able to maintain that right with the supported decision-making document, or, you know, several supported decision-making relationships. So we have a couple toolkits on our website that go through in pretty great detail supported decision-making, what it is, how you can set it up. But what we wanted to highlight was that on the kind of spectrum of decision-making support options, supported decision-making is a less limiting but still formal and legally recognized option of supporting somebody where they get to make all of their own decisions, but they are able to identify people that they want to support them or assist them in making those decisions about where they live, or their finances, or those kinds of things. So then full guardianship or limited guardianship is kind of on the other end of the spectrum, which is a much more limiting option as far as these support relationships. And so that in those cases, all or some or all of the decision making is transferred from the individual to a court appointed guardian. And in that case, then, like Patty had to go through, you will have to go through the process of trying to retain the right to vote as part of the guardianship, or going through the process after you have a guardian of getting the right to vote back. So there's lots of options out there. Supported decision making is just one of them, but it is one where you're able to maintain the right to vote while still formalizing some relationships to help you make choices in your life. So I'm going to share the link to this toolkit in the chat and also on the Facebook Live. There's a full guidebook as well on the toolkits page. I'm just going to go click back and I'll show you that really quickly. Let's see if it'll change pages. So on the toolkits page of the WI-BPDD.org website, there's a supported decision making and guardianship alternatives guidebook. And right below that, there is the supported decision-making toolkit, which kind of helps walk you through the whole process. And at the end of it has supported decision-making agreements that you can fill out with somebody. And those agreements only need to be either witnessed by 2 people or signed by a notary. You do not have to go to court to have those agreements formalized. So those are some options that are available. We have a lot more resources on supported decision-making. We often have talks. Some of those are on our Facebook page. And we may be tackling it in the future as part of Living Well Wednesday as well, if there's interest in learning more about what supported decision making offers as an alternative to guardianship. So I think that if there are no questions, that's the end of my little spiel.
All right. I think there was maybe some thought that Mitch might have some comments about some of the things Patty said, but I'm not sure. So I'm gonna give him a second.
I'm back.
Okay.
Yeah, I did just want to mention one thing, and that is, I mean, Patty, Patty is right. I mean, it's really important that people, once you get your right to vote back, that you do the best you can to make a informed choice and learn everything you can about the candidates. But I just want to make sure people understand that the legal standard to get the right to vote back doesn't involve understanding the candidates. It's just whether or not you understand the process. And so the process is, an election is to pick one person to make decisions for you. And if you know, I mean, we've watched elections. In my opinion, about half the people make the wrong decision every single time they vote. But it's not my decision. It's not the court's decision to inquire about, whether you understand a candidate's position and if you're, if the conversation that you're going to have with the judge about this process shouldn't go much beyond, well, why do we have elections? Well, we have them so we can pick the people who make decisions for us. It shouldn't go to, well, okay, that's great. Now who are you going to vote for in the next election? That should not be part of what's going on in this court proceeding. This is, it's do you understand the process? If you can understand the process, you get the right to vote back. Once you get the right to vote back, you can vote for whoever you want for whatever darn reason you want. If you want to only vote for red-headed candidates, that's your prerogative. If you want to vote for Mickey Mouse and write that person in, you can do that too. That has nothing to do with whether or not you understand why we have elections. So don't feel like you have to, before go into this court proceeding, have studied the election that's coming up and figured out who you're going to vote for and why, and why that candidate's positions are in line with what you agree on philosophically or whatever. Those are all good things to know before you actually vote yourself, but they don't really have much to do with, whether or not the court thinks you should have the right to vote back. And the process Patty described with her daughter just is appalling to me. That's not the way it's supposed to work. Nothing about the guardianship is supposed to be rushed like that. So I would hope that if you do use this process and use one of our forms to get going, that your experience is nothing like that, and that it's a lot more like what Jenn experienced, which is, there should be a discussion, you and the judge. Do you understand why you have the right to vote? Yes, here's why. Great, go ahead, vote. We need you in the process, and welcome to it. That's what should happen. So
are there, and I think Patty's asking this question too, and just a shout out to George Zasky, because he too is on here saying that the standard for competency for voting is the lowest level of decision making. But Patty's saying that maybe just even the guardianship, like good resources on being prepared kind of for that process, because I think that is what you're saying is true. And someone not knowing and then being in that situation of, well, that's the judge, and now I'm disagreeing with the judge and feeling, overwhelmed and threatened. So, maybe, I know we have the brochure out there. Are there any other places that you would recommend for resources on guardianship?
yeah, the best place is a place called the Guardianship Support Center, which is run by the Greater Wisconsin Agency on Aging Resources.
Yeah, and I bet Caitlin can quickly get that and put it in our chat. So that would be great.
Tons of stuff on guardianship. And, we hear from parents who kind of get channeled into the guardianship system around the time their child turns 18. And I mean, they really don't have any idea what they're getting themselves into, and they're not ready for that process, and they're completely blown away by it. And unfortunately, I mean, it's not universal, but a lot of courts don't take these things particularly seriously. They assume that if somebody bothered to petition for guardianship, if someone has a cognitive disability, that, you know, it's like the old days where we just take away everybody's rights. And it's not supposed to be like that. And the more you know about the process and how it's supposed to look, where there's supposed to be a determination, an individual determination by the judge about whether or not a right should be taken away. If you understand that going in, and you know you're ready in case the judge gets all huffy and judgy with you, you know, you can fight back and say, well, I guess we're not going to get done today, Judge. You're going to have to schedule that for a couple weeks. You know, your fault. You didn't set enough time for it. Kind of hard to tell a judge that, but you do have the right to do that.
Right. Well, and we do think this is an important issue. So we haven't invited any of our speakers yet, but we are definitely considering this topic in September. So something to look forward to. I thank everybody for participating today. It was really great. It was a great discussion. Next week, we'll be doing Living Well Wednesday. We'll be talking about the BPDD newsletter, and also having a guest speaker from our August newsletter on What's the Word. And then we'll also be talking about the ARC Wisconsin has a new program that they are launching this month. So join us next week. We'll send out an invite through our Facebook page and emails. So look for that. And thanks a lot for joining us. We really appreciate it. Just give me a